Well, good afternoon, Your Honor.
Good afternoon.
Thank you for agreeing to be here with us
Thank
this
you
afternoon.
for wanting to take this oral history. I deeply appreciate it.
Well, we're looking forward to it. Of course, we're here with your friend, Mike Sabbath, of the law school. And we're here with a collection of students and family and friends, and we appreciate all of you being here.
Yes, we do.
And we're here, of course, to talk about your life, talk about you, your career as a judge, your service to Mercer University over the last 60 some odd years.
Quite a few years.
Quite a few years. But we need, I guess, to start at the beginning. And so if we can talk about your time growing up. You grew up in Newnan.
Grew up in Newnan, but prior to that time, I was born in Colquitt, Georgia, which is a small South Georgia farming community of about 1,500, 2,000 people. Miller County. At the age of 5, we moved to Cuthbert, Georgia, about 50 miles up the road. My dad was superintendent of schools in both communities. And then on to Newnan when I was 8. And that was 1941, which was about 3 months before the beginning of the Second World War.
All right. Well.
And Newnan was a great place to grow up. It was a very affluent West Georgia cultural little town of about 7,000 then. It's about 35,000 now because of the sprawl of metro Atlanta. But since my dad was superintendent of schools, you can imagine that my brother and I were admonished to observe certain kinds of deportment, which we tried to do throughout our youth.
Well, Judge, as you know, through our conversation this afternoon, from time to time, I'm going to be showing you some items from your scrapbooks that you were so generous to share with us. And the first thing that I'd like to show you is this picture of, well, why don't you tell us about who those people are?
Well, my mother and father and my brother Henry. And now just when that was taken, I don't know, but probably in Newnan. And my brother was about 3.5 years younger. His name was Henry. He went on to become a doctor, and died prematurely at age 62. And we had very loving parents, I might say very educated parents, both were, particularly my father, who stressed the importance of a good education and a good character, and spoke to us quite a lot about that.
So what was it
So
like?
we tried to do what they wanted us to do, particularly I did.
Well, I think I have some evidence that you did, Your Honor.
Maybe I was a little more responsive to what they wanted than my brother was.
We have here your 4th grade report card.
Oh, you put that in there.
And just as evidence that you in fact did as your
Well,
father.
he would accept nothing less, you understand. So that was made clear. We had a quite normal childhood, but nevertheless with great expectations. And they believed in knowledge, and that combined with good character, they thought would lead to ultimate success in whatever you wanted to do.
What did you do for fun growing up in Newnan?
Well,
at
we
that
went
time?
that was the beginning of the Second World War. So for fun, on Saturday mornings, we went to the movies. It was done all over the South, I'm sure. It was about 12 cents. And we played sports and generally enjoyed childhood with our friends who lived very close to us. And Newnan was, as I said, a very exceptional town and had a very enjoyable youth. My dad was a scholar, I would say, and he believed in passing along to his boys some advice and he was a great admirer of English literature, Shakespeare, Rudyard Kipling. You might remember this quotation from Hamlet, when Polonius told his son Laertes that above all to thine own self be true, and then as night follows day, you cannot then be false to any man. He ingrained that into our heads.
It's still there.
And he believed in self-control. And he also told us many times that live your life as if one day you're going to be investigated. And one day you will be. And that's by yourself. And that when that happens, you're going to want to like what you see. And I've never forgotten that.
Well, you must have taken his advice as a young man, because as you see here, you graduated from, I assume that's Noonan High School?
Noonan High School.
All right. And for those of you who can't
I
see
was
it.
probably in the Colquitt paper.
Well, all I know
Miller
is
County Liberal.
it was in your scrapbook. That's all I know. But it says, for him, many laurels.
Many laurels, yeah. Well,
And then after doing that and doing so well, you spent some time at Mercer, and Mercer University is going to come up a lot during our conversation at various points in your life. But you chose to come to Mercer to get your undergraduate education, and this was the beginning of, what, like 60 years of your association
that's
with Mercer.
about right.
What made you choose Mercer, and what was it like in the early 50s at Mercer University?
All right, I'll tell you. First of all, I started school. I wanted to go to Mercer at the outset, but my dad was a graduate of the University of Georgia.
Sad.
I went to all the Georgia football games growing up, so I ended up going to the university for 1 year. I didn't particularly enjoy that year, although I was successful academically, and thought that the smaller school, I was very active in the church, and that Mercer at that time was a very small Baptist-oriented school. I'd been down to Mercer during my high school years at debate tournaments and one-act play contests, so I was familiar with the school. And so after a year at the university, I transferred to Mercer. Everybody in Noonan thought that I was coming down here to be a preacher, but that didn't happen. I was really pre-med, but that didn't last long either when I got down here with all these lawyers. But Mercer University back then was about, I would say, 1,000 to 1,100 students in the early 50s. And that was during the Korean War, you know. And so most of us were members of the ROTC because if we had to go to this service, and all of us would have to eventually, wanted to go in as an officer. And so the only graduate school we had at Mercer at that time was the law school. Since then, we've added 10 more, and a great deal more students, as you know. But the school had some very rigid standards back then. You had to attend chapel 3 times a week.
3 times.
They assigned you seats and took the roll, so you had to go.
They were serious.
Serious. And there were many restrictions on the girls, the women. And we had about 3 dormitories then, the old one, Sherwood Hall, Shorter Hall, and Roberts Hall. And I think the women had one MEP, which is still here, Mary and Porter Hall. And Mercer had some great teachers, many in the Christianity department, which were very impressive to me. Dr. Lewis Batts, Dr. Harold McManus, Dr. Kelly Barnett, some of those, and our pre-med department was outstanding. And if you went to undergraduate school at Mercer and wanted to go to medical school and graduated from Mercer, that was almost accepted that you would be admitted to medical school.
Did you have classmates who you maintained contact with?
Yes, classmates,
life?
one in particular that was a good friend from Nantucket Island, Massachusetts, named Wayne Holmes, and we corresponded until his death this last year, and but many others. And I'd say the law school back then was about 80 to 100 students. It was located on the campus, not here, in the Riles Law Building. And we had some great law professors. Hodge O'Neill was the dean, and then you know some of the other deans, Ed Wilson, who was here, and a dean of the law school, and subsequently Mayor of Macon, Jim Quarles, Jim Rayberg, who taught here until his mid-80s, did he not, Michael?
And until actually into the early 2000s. He was
Exactly.
until he was 85.
Exactly. So we had some very good professors, and one named Charles Nadler. And a room here is named for him.
Yes, sir.
And he was a lawyer from Cleveland, Ohio, who made a lot of money in law practice in the 1930s, married a Macon girl, moved here, taught for $1 a year here at the law school, and happened to teach bankruptcy law. And oddly enough, my highest grade in law school was in that course, which was an omen, I suppose.
How's that worked out for you so far?
Unknown to me at the time.
So undergraduates brushed elbows with the law students back then?
Yes, they did, but not too much. Most of our students, a lot of them at least, were Korean War veterans. See, that war was going on and just ended, and they came back to law school. They were married, and as a result, some of the students like myself were still living in the dormitory with all of the distractions that you can imagine existed in the dormitory.
You're not talking about chapel.
No, I'm not talking about chapel. I'm talking about the fact that these people who were settled, married, made the best grades. You know, I like to tell folks that I did finish 4th in the class, and that sounds quite admirable and successful. But when you consider there were about 18 in the class, that's not so impressive.
Well, Judge, you did okay. I mean, after all, at least according to your scrapbooks, you were the president of the law school student body.
Well, that may be, but I thoroughly enjoyed law school. And but I've told Mike this before, that in the spring of 1953, because of the urging of a lot of folks in Noonan, that I could probably practice law easier with an Atlanta firm if I went to Emory. So reluctantly, I took that step and started law school at Emory. Stayed there about a quarter. Had some great professors there, Bob Hall, ultimately Supreme Court Justice, U.S. District Judge, Ben Johnson, who was the dean, subsequent dean at Georgia State University Law School, Tom Christopher, many others. And but Emory had an Air Force ROTC program, and I didn't want any part of that. I came back to Mercer, finished law school. I was very, very happy here, and don't know of a better place for anybody to secure an education, either undergraduate or professional, and enjoyed every minute of my law school experience here.
Can we talk about the ROTC experience you had a little bit? Because you did that it was during law school.
That's right.
As well.
That's right.
And
And I thoroughly enjoyed the military.
Right, and that's what I
And-
wanted to ask you about, because it seemed to have been a very important influence
It
on
was.
you. And I was wondering if you could talk about the ROTC
Well,
experience
the
a little bit.
ROTC program at Mercer was a quartermaster ROTC. And we had, I suppose, about 300 to 400 in the program. Most of the men, I say, were ROTC students. And following graduation, we went to camp at Fort Lee, Virginia. And after that, well, I will tell you this, while there, and I may be skipping a little bit, but while there, my dad called me one Sunday morning and told me that I'd passed the Georgia bar examination.
That's good news.
So that was excellent news, and the very next morning, Monday, I went down to the personnel office and asked for the forms to transfer my commission of the quartermaster to the JAG Corps. So, but before that happened, I was assigned to the 3rd Infantry Division at Fort Benning as, can you believe, the Graves registration officer in a company. And right after that, we went on maneuvers in the wilds of Louisiana near Fort Polk. And on maneuvers, I was the petroleum oil and lubricants officer and the PX officer.
It's not your highest and best use.
And not my training at all. Knew very little about what I was doing, really. But while there, word came that I had my application for the JAG Corps had been granted,
Right.
approved. But I stayed for the next 2 weeks in Louisiana, finishing my tour of duty on this maneuver, which pleased my superiors, but I could hardly wait to get back to the division to go into the JAG Corps.
Makes practicing law look a lot more fun.
You know, when you're on the general staff, that's a little different from being a quartermaster officer.
Can you talk a little bit about your time in the JAG Corps? I know from our previous conversations how much you enjoyed that and how much you learned
I
from
enjoyed it so much, I almost made a career of it.
Tell us a little bit
I
about
got
what
a
you
great
did.
deal of trial experience. I was a trial counsel for the division, prosecuted all kinds of criminal cases, murder, rape, robbery, all kinds. You know, there are 3 levels to an Army. Under the Uniform Code of Military Justice, you have summary proceedings, which is the company commander, special court-martials, which is at then the battalion level, I don't know what they call it now, and the general court-martial, which is the division level. And we were trying the general court-martial. And so spent 3 years there. As I said, was a trial counsel and then the chief of military justice. Got a regular Army commission, had intended to stay in the Army as a career. I would have thoroughly enjoyed it. I enjoyed the discipline.
Okay.
I enjoyed the atmosphere. You know, it's a lot different from being in a line company. But
What did you like about trying cases? I mean, in the courtroom, you had a lot of experience doing that.
well, I did. I thoroughly enjoyed the trial experience, the combative nature of the courtroom, and the judges in the general court-martial system were officers in the Army appointed by the general, usually colonels. And you might have a brigadier general maybe sitting as the president of the court. And it was a tremendous experience. And when I'll tell you a little bit about how my desire to be an Army officer concluded. And that happened one day when the Governor Ellis Arnold called me on the telephone. He was a native of Newnan, longtime family friend, and had been governor of Georgia back in the early 40s. And he said, Homer, next time you're in Newnan, I'd like to see you. So,
That sounds like a command performance.
well, it was a command performance, I think, that was arranged by my father and mother, who did not want me to pursue a military career. And so Governor Arnold, I went over to see him when I was at home, and he offered me a position in his law firm in Atlanta. He and my dad were good friends, so, you know, 2 and 2 makes 4. So that's how my desire to have an Army career came to an abrupt halt.
You know, it's interesting. I assumed it was a large firm. And,
It was not a large
but
firm.
it wasn't. It was 7. Did you tell me it was 7?
Well, not even that. It was Ellis Arnold, Saul Golden, Cleveland Gregory, Fred Gober, Elliot Levitas. You may remember Elliot
That's a
Levitas,
cast of all-stars.
congressman from Atlanta later, and Rhodes Scholar, and myself. And that's it.
And you went from being in the courtroom trying cases.
I didn't stay at Arnold, Golden, and Gregory but a year because of the fact that, you know, when I had that captain's bars on in the Army as Chief of Military Justice, and going in as a lowly associate in a firm like that and drawing leases and contracts and never seeing the courtroom did not exactly appeal to me.
Sounds deadly dull.
It does. It was for me.
Well, then you left to come start a small firm
In
in Macon.
Macon.
Now, what did your father think about you leaving?
Well, he really didn't object to it because he knew I needed to do something else because of being unhappy in that situation. So there was a friend I went to law school with named Fred Hasty, and he and I began a law firm here called Hasty and Drake that didn't.
You made the paper.
Yes, that's true. In the Macon paper, and we practiced together, I suppose, for about 6 or 7 months only, and I still desired to try cases more. We didn't have much trial practice. Jack Kennedy won the presidency, and I was. Back then, almost everyone, you know, in Georgia was Democrat, and
Things have changed.
things have changed.
Yeah.
So Floyd Buford, after Kennedy's election, was appointed United States Attorney here in Macon. And so Floyd asked me to come over to his office, and this was at the urging of Senator Talmadge, who was urged to write Floyd on my behalf by my good friend and neighbor Walter Sanders in Newnan, a practicing attorney in Newnan, and a good friend of his, Talmadge's. So he offered me a job as assistant U.S. attorney in Macon. I accepted that job, and then strangely enough, about 2 months later, before I was scheduled to come on board here, I got another call from Walt. He said, Homer, I've changed my mind. I think it'd be a lot better for you to come back to Newnan to be the law clerk to my good friend Lewis R. Morgan, Pete Morgan, who was the first district judge, United States district judge, appointed by President Kennedy. Said he was going to be appointed very shortly. So, because I had great confidence in Walt Sanders' advice, I did that and went to tell Floyd of my decision. He fully agreed. plus the fact that law clerks back then made a lot more money than assistant U.S. attorneys. That's not true necessarily today. Things have changed. But, so I then moved back to Newnan to become, and Judge Morgan's headquarters, his principal office was in Newnan. And so that's how I began my career in the federal court system.
And I think we have the clipping from when Judge Morgan was sworn in.
That's right. You notice the other two judges were up in years. Those are the only three judges we had in the Northern District at the time. Judge Hooper, Judge Sloan. And Judge Morgan, being 48 years old, was assigned most of the large cases that were filed in the Northern District. And you might remember the case of Georgia's football coach, Wallace Butts, against the Saturday Evening Post, or they call it the Curtis Publishing Company case.
We might remember it, but tell the story.
When the Post ran an article accusing Coach Butts and Coach Bear Bryant of conspiring to throw the Georgia-Alabama game in Birmingham at Legion Field in I believe it was 63. That case attracted attention from all over the country. Morgan was assigned that case. I worked on that very closely with him, and Coach Butts won a $3 million judgment against the magazine.
It was quite a bit of money back then.
Quite a bit of
too,
money
wasn't it?
back then,
Yeah.
and that was the punitive damages. The other damages were assessed at around 60, but the case was tried in about 2 weeks. They told us it'd take 2 or 3 months, but Judge Morgan was not the type that would do that. He was very insistent on things being done and quickly. I got that from him and still run my courtroom the same way, very formally, and not much nonsense. And so, well, before I finish that story, Bill Schroeder of the Atlanta law firm of Troutman, Sam, Schroeder, and Lockerman was Butts' attorney. The attorney for the Curtis Publishing Company was Kilpatrick, Cody, Rogers, McClatchy, and Regenstein, now Kilpatrick Stockton. And the young lawyer you might have heard from in the Atlanta bar, Emmett Bondurant, was a young associate in Kilpatrick at that time. And he and Welbin Cody, who was a senior partner, tried the case for the magazine. And in the closing argument, Schroeder was quite a showman. And he said, "Ladies and gentlemen of the jury, when Coach Butts dies, they're going to put him in a red and black coffin. He's going to have a football cradled in his arms. And on the outside of the coffin will be these words, 'Glory, glory to old Georgia.'" You can imagine how that affected the jury.
Brought tears to their eyes.
And resulted in the verdict I just mentioned.
So Judge Morgan obviously was a mentor to you. I mean, it
Obviously.
sounds.
Obviously.
Were there others at the time, as you were just beginning, you were a clerk, other lawyers you saw, other lawyers you consulted?
Well, I mentioned two already,
Sanders.
Governor Arnold, Walter Sanders, and Judge Griffin Bell. I think you may have heard of Judge Bell.
Yeah, we have.
His office was right down the hall from Judge Morgan's. And so I saw him quite frequently, got to know him well way back in the early 60s. And a lot of the Mercer meetings we had at that time, when I was involved with the Alumni Association and other things having to do with the law school, we met in Judge Bell's conference room. And as he was also intimately involved with Mercer. in almost every respect back then.
Well, you went from being a clerk to, at age 31, very young, being a referee of the bankruptcy court. Now, tell me how that came about and what you thought when it was first suggested to you that you accept that position.
Well, let me go back and remind you that the highest grade I made in law school was in bankruptcy law. But
You hadn't
that-
seen much of it since
I
then.
had not seen that except insofar as appeals came to the district court to Judge Morgan from the then referees in bankruptcy in Atlanta. These were, for the most part, very older men. There was only one in Atlanta, I think perhaps two. One of them was Judge Hooper's former law clerk, who went on to become a professor at the University of Georgia, Ray Phillips.
Oh, yes.
You may remember
I do
Ray.
remember Ray, yes.
And then Judge Ellis Mundy, who was the United States Attorney under Harry Truman, but when Eisenhower became president in 1952, then he was replaced by Ed Dorsey in Atlanta. And then the judges Hooper and Sloan, the only two then, appointed Judge Mundy referee in bankruptcy. So he was still there. The way I got to be referee was the fact that I was the law clerk to the chief judge. And back then, the district court made those appointments. And Judge Morgan said, Homer, if you'll stay with me an extra year, I'll appoint you referee in bankruptcy. That sounded good to me, so, a good salary back then. And so I...
Now, let's be sure what we're talking about here. This is the paperwork of your appointment as a referee. Now, that shows salary upgraded to $15,000.
Well, that was a lot of money back then.
Okay.
I was making about 10 as a law clerk. And
If you say so, Your Honor.
that's right. And the district judge was making about 22.
Okay.
I'll tell you more about that later, but I thought that would be quite a challenge. When I got there, I've never seen the office was in a shambles. They held court. Of course, for the people here, a referee was an unfortunate name for the bankruptcy judge, which took us 9 years to get changed. And people didn't know the general public didn't know the difference between a referee, a trustee, or whatever. So Judge Mundy was holding court around a table in his office. No robe, no anything, no accoutrements of office of any kind, which was anathema to me, having been with Judge Morgan and seeing all of what a court should be. So I set about doing what I could to change that. And because I had the support of Judge Morgan and Judge Bell and several others, I was successful. I began wearing a robe. You can imagine how the bar in Atlanta viewed that, this young 31-year-old coming in here and trying to change all of this business. But they responded very quickly. Matter of fact, we got a courtroom assigned to us then, such as it was, a few benches, and what passed for a bench. And that lasted for a few years as we were making an effort, several of us throughout the country were making an effort to upgrade the bankruptcy court into what we thought it should be.
Judge, I think this picture is from 1969. I'll point out that's Judge Bell on the credenza back there, is it
Exactly
not?
right. That's true.
Now, this is the same time period you're talking about as you
Same
try
time
to
period.
try to upgrade from the referee around the
That's
table.
right. That looks about 31 years old, doesn't it?
Well, you were a little bit older then.
Before Pat talks about all the work you did to upgrade bankruptcy practice, I want to detour a little to your personal life. It was about this time that a very important event took place. You married a Miss Ruth Bridges from Dawson, Georgia.
The most important event of my life.
The most important event of his life. Tell us a little bit about how you met Ruth and a little bit about your courtship, just so we understand your personal life a little
When
bit.
I was at Mercer, I knew who she was. She knew who I was. I was a senior in law school. She was a freshman in the undergraduate school. I was dating one of her sorority sisters who was also in law school. We did not formally meet, I don't think, but we went to some intramural basketball games, volleyball games in which she participated,
She was a volleyball player
and basketball.
and basketball. Okay.
And so I knew who she was. She knew who I was. And then later on, oddly enough, Ruth was an elementary school teacher in DeKalb County and taught the fifth grade. She did not like Atlanta that much and was looking for an opportunity to teach somewhere else. A friend of hers happened to tell her one morning that they were going to Noonan and that she should come with her and would see if she liked the school system there. She did, came down to Noonan, happened to meet my father while she was here, and he offered her a job. And Ruth said, well, Mr. Drake, you know, that sounds mighty good, but I don't believe that I can afford to give up this bigger salary in Atlanta. And he said, oh, no, we can pay you the same thing. So that happened. She moved to Noonan, I think, in 62 or 3. We began dating some off and on, not seriously. And then off and on for the next 5 or 6 years. And finally, she went back to Atlanta. When I was so involved in my career, I was foolish enough not to devote more time to this young lady that eventually became my wife. So when Ruth came back to Atlanta to teach, I already had an apartment in Atlanta at Cross Creek and was on the bench. We dated rather seriously and got engaged and married in 1969.
Right, and there you made the paper again.
Best thing that ever happened to me. You know, the love of my life. And I can talk about Ruth all day, these two wonderful boys that we've had together, Walter and Taylor.
So it's working out okay so far.
And our great 6 grandchildren, one of whom is here today, Harrison, that we love so much. And but I better get off that subject because I'll talk about Ruth too
You
much.
know, your father played a
I may
role
get
again in this thing,
I get a
hiring
little too
her.
emotional.
Yeah, your father's been a real influence in a lot of different ways in the direction your life
Oh,
is.
yes, he has.
That's good.
Quite influential, as has my mother. I don't want to give you the impression that she was not, but, you know, there's always a lot of power behind the throne.
That's true.
That's a good example.
Like in your marriage, for example.
And in my marriage.
And
And
we
that
know
that
Ruth.
is especially true in my marriage.
That's true.
Judge, the bankruptcy system was one thing when you started, and it's another thing today.
Quite different.
And that evolution and how that happened, particularly leading up to the Bankruptcy Reform Act, this is a story that needs to get told about how that came about, and particularly your role in it. And I don't want you to be bashful about this. Tell us a little bit about how it got started that you and some of your colleagues on the bench got interested in seeing these major changes, and what steps did you take to see it come about? And I'm going to ask you along the way about the obstacles you encountered, because there were a number of them.
Many. This began in the late 1960s. Several of us had been appointed at about roughly at the same time. About 7, I would say, a number countrywide. I'll name them: Conrad Sear from Maine, Joe Lee from Kentucky, Bob Morton from Kansas, Dan Cowens from California, Arthur Moeller from Houston, John Copenhaver from West Virginia, myself, and a couple of others who had been with the system quite a while, Clive Baer, and later on Asa Herzog from New York, Clive Baer from Knoxville, Tennessee. All of us were experiencing these difficulties, some of which I've mentioned to you, and were determined to do what we could to upgrade the system, to create a court that could get the job done to serve the public appropriately. Under the Bankruptcy Act of 1898, clarified further by the Chandler Act in 1938, which created the Rehabilitation Systems, Chapter 13 and others. The role of the bankruptcy judge was severely limited, not only by virtue of the unfortunate name, referee in bankruptcy, but in jurisdiction as well. Summary jurisdiction was reserved for the bankruptcy court, plenary for the district court mainly. So we set about to change that. About that time, some of the leading bankruptcy lawyers in the country, principally members of the National Bankruptcy Conference, professors, lawyers in big metropolitan areas, professors like Frank Kennedy of Michigan, Vern Countryman of Harvard, Larry King of New York University, and many others, Charles Seligson, who was quite a moving force in this, convinced Congress to create a bankruptcy commission made up of 9 members, 3 of whom were to be appointed by the President, 2 by the Chief Justice, 2 by the Majority Leader of the Senate, and 2 by the Speaker of the House.
And now this was to study
Study
changing the system.
Changing the system. The resolution that the Senate adopted, Senate Resolution 88, made clear that the Senate wanted the Judicial Conference of the United States, meaning the Chief Justice, Warren Burger at the time, to appoint 2 referees in bankruptcy as his representatives on this commission, because obviously we knew more about the subject than anybody else.
Sure.
Certainly more than district judges or circuit judges. Well, Burger did the exact opposite. He appointed 2 district judges who felt as he did about this business of upgrading the bankruptcy court.
It wasn't just any 2 district judges.
No, it was not just any 2. One was chairman of the Bankruptcy Committee of the Judicial Conference, Edward Weinfeld of New York, and the other one was Hewitt Will of Chicago. Even though we had no representation on the commission, we did the best we could through the National Association of Referees in Bankruptcy. Like, we changed that name very quickly. Well, I'll tell you about that later. Did what we could to cooperate with these people to upgrade the system. Testified before the commission on many occasions. And tried to work within the framework of the judiciary and not outside it to have our voice heard. Well, our voice was not heard by Judge Weinfeld, who was chairman of the bankruptcy committee, or by many of the circuits and many of the districts who made up the Article III bench in this country, who did not want this
And
elevated bankruptcy
And why not?
court.
What was
I
it?
think it was a turf thing. They thought that perhaps an elevated court might somehow jeopardize their prestige or position. And so we had extreme difficulty with some of the Article III bench. We did not experience that opposition in Atlanta and or some other major cities. The makeup of the judges I just mentioned, these seven had a great deal of latitude in their particular districts in working with us to try to get our positions as to what the court should look like across to the judiciary. So finally, Joe Lee from Kentucky, who was one of the principal drafters of the judge's bill, which I'll mention in just a minute, wrote Edward Weinfeld, Judge Weinfeld, a letter seeking an audience with him to tell him that we needed representation on the Judicial Conferences Committee and other things. And he said, we're not going to have any referees on this bankruptcy committee of the Judicial Conference. And if you think you need to have some input into what's going on with the commission, you can just go to Congress. Of course, that's what we were waiting to hear. So once we never let Judge Weinfeld or Chief Justice Burger or any of the others forget that invitation. So from that point forward, we ignored the Judicial Conference and went directly to Congress. The Bankruptcy Commission reported its bill out in about 1973, in which they recommended that most of the functions of the bankruptcy court be handled by an administrator to be appointed by the president. Access to the judicial process, meaning to a judge, was cast out. And this administrator really was to run the system except for a few cases that would be tried by, say, about 50 district judges.
And to our ears today, that sounds
It sounds
very strange.
very strange,
Because
and was then.
It's judicial power.
Well, it's a question of access to the judicial process,
Right.
which we wanted to maintain, of course. And so after that came out, we decided to write our own bill called the Judge's Bill. So that was done over a period of months. We had meetings with the main lawyers in the country in the field of bankruptcy law from the National Bankruptcy Conference, and some members of the commission, even staff, like Judge Charles Felix and Frank Kennedy, Vern Countryman, met 2 or 3 times in my office in Atlanta to try to work out our differences and make the court what it should be. We made a great deal of progress with them, but not enough. And it was about this time that the Judicial Conference, through the efforts of Weinfeld and Chief Justice Burger, decided that the recent raise to U.S. district judges to $40,000 and the corresponding raise for referees in bankruptcy to $36,000 was not to be. They considered the $36,000 entirely too close to their own salary. So they, on their own, ignored the will of Congress and reduced referee salaries to $30,000 from $36,000. You can imagine what effect that had. It was extremely frustrating to all of us. And this was going on now for several years. And I suppose we lost 6 years of pay as a result of that. So this caused a redoubling of our efforts in Congress. About this time, the Committee on Bankruptcy Rules of the Judicial Conference came out with a new set of rules, which they do periodically still, Michael. Among which this time was a change in the title, which we'd been working on for many years, from referee in bankruptcy to bankruptcy judge. We immediately changed the name of our conference to the National Conference of Bankruptcy Judges. I happened to be president of the National Conference at that time and had our convention in Atlanta, at which Judge Griffin Bell was a major part. The then governor of Georgia, Jimmy Carter, came to speak. The then mayor of Atlanta, Maynard Jackson, came to speak at my invitation. And the main speaker was Senator Herman Talmadge. It was at the Hyatt Regency in downtown Atlanta. We had more people there than we ever had before. It gave us quite an opportunity because Senator Talmadge had a great deal of influence in Congress, particularly with the chairman of the Judiciary Committee, Senator Sam Ervin of North Carolina, who at the same time had just been appointed chairman of the Watergate Committee to investigate President Nixon. I wrote Talmadge's speech.
Well, let's talk about that speech.
And
What did you have the senator say?
well, we did not want the administrator. That would have destroyed the system. It would have destroyed access to the judicial process.
And that was the commission recommendation.
Commission recommendation. So Senator Talmadge made the speech that he was totally against any additional federal bureaucracy that would spend untold millions of dollars at the taxpayer's expense.
It's a line he'd probably used before in other
Many times in other speeches, but left no doubt that he did not like the administrator concept because it was just an extension of another executive branch spending too much money. And we got that across in the speech. And he was very kind to come to Atlanta to deliver that for us. That helped tremendously.
And he actually did more than that. You see, this is his letter to you about that speech. What did he do with the copy of the speech?
What did he do with the
Well,
copy?
well, he put it in the congressional record.
Oh, yes, put it in the congressional record.
Right.
And did some other things for us. He got us an appointment, Judge Sear and myself, with Senator Ervin, chairman of the committee, who had already held up the federal rules of evidence for some reason. We didn't want him holding up these rules that I just mentioned to you, changing the title to the bankruptcy judge. So we went to see Senator Ervin, Judge Sear and I. Had a very cordial meeting with him. He promised us that he was on our side. He thought very highly of his good friend, Senator Talmadge, and on and on. So that helped greatly in getting what we wanted done. And so then about that time, as a result of the continued frustration that we had, we seemed to be making very little progress. Some of us became a little disheartened and frustrated, particularly with the loss of the money. And I elected at that time to go into private practice in Atlanta. This law firm in Atlanta did not have a bankruptcy presence, and they wanted one very badly.
That was Swift Curry.
Swift Curry,
And,
McGee, and
and
Hires.
I want us to talk about that, but I want to see if we can finish, and I know it takes a little bit out of the chronology of your life, but I want to see if we can finish the story of how the Bankruptcy Act came to be.
Yes, we'll do that, but this was an interruption, at least in my life.
Okay.
But that did not dissuade me from continuing to work to improve the bankruptcy system. As a matter of fact, it might have given me a little bit more leeway being in private practice, which I continued to lecture at seminars all over the country for the next 3 years before coming back to the bench, but I'll get to that. And the Bankruptcy Act of 1978 was the result of all of this effort that the Bankruptcy Commission and the bankruptcy judges and the NBC had all the efforts that had been entered into and made for those, 8 or 9 years. And I think it's the best piece of bankruptcy legislation ever passed in this country. And for the most part, still governs the context of bankruptcy proceedings, except for the structure itself, which the Supreme Court changed in 1982 in the Marathon Pipeline case.
Now, when the legislation gets passed, now, is it mostly in the form of the judge's bill?
It was a combination of the two. We prevailed in getting rid of the administrator concept and returned everything to the control of the judiciary, where it
But
belonged.
the judge's bill, would that have made bankruptcy judges Article III judges?
It would have, but that was not going to fly at that time. So the commission wanted to make it Article III as well, except they just wanted 50. And we had over 250 judges. And those of us who were officers of the conference and were judges ourselves knew that unless they made the incumbents Article III judges, the political process being what it is, the fact that we were prohibited from engaging in politics once we were on the bench was unlikely that many of our people would ever get to receive that appointment and serve on the bankruptcy bench.
So the final bill is a
final
compromise.
thing was a transition
Okay.
of 5 years. It ended up that President Carter waited until the final day after Congress had passed it to sign the bill. And he did that over the strident and vehement opposition of the Chief Justice of the United States.
Tell us that story once the bill has arrived to the president. And
He even wrote the president a letter saying that you don't want to sign this legislation. It would decimate the federal judiciary. And then even, I think, came over to the White House at one time to talk to the president, unprecedented.
what's the Chief Justice of the United States doing
I
coming
have
to the
no
White
idea.
House?
But he was not our friend, and that's putting it mildly.
But you did have friends
We did have
who
friends.
helped you.
We had friends where it counted.
So it's on the president's desk. The Chief Justice has said, don't sign it.
And Stuart Eisenstadt, who was one of his top advisors, Bob Lipschutz, was chief of staff to the president, who very much wanted this legislation that we had written. And a judge again, you may have heard of Judge Griffin Bell was the Attorney General at the appropriate time. So he urged the president to sign the bill, and he signed it on the last day. What it did was to make the appointment of bankruptcy judges a presidential appointment, but for a limited period. In other words, not during good behavior, not life tenure. Instead, appointment for a period of 14 years. A legislative court, in other words, instead of a constitutional court, with a transition period of 5 years for referees or bankruptcy judges then serving, and then who would have to be appointed by the president after a period of 5 years, and not knowing which party may be in power then or whatever. But that didn't materialize, because in 1982, the Supreme Court issued a marathon decision saying that there are certain things that a legislative judge cannot do. That has to be reserved for a constitutional judge, things having to do with state law, contract claims that did not bear directly on the bankruptcy process. So back to the drawing board.
Mm-hmm.
And that at that time, the people involved in bankruptcy, the major practitioners, the professors, the bankruptcy judges, all urged very strongly the creation of an Article III bench as being the only way to solve the problem.
Sure.
And it was. It still is. And until that happens, we'll never have the system that we deserve in the bankruptcy court. We'll get to that a little later.
Mm-hmm.
But this was the first shot across the bow, and should have alerted everybody that that's going to happen eventually.
Right.
But still, it was stymied by the Article III bench, the Supreme Court. And so what they did was to make the bankruptcy court a unit of the U.S. District Court. Move the appointment, though, from the District Court to the Court of Appeals, where, you know, if you're going to have any appointment in the judiciary, it should come from the Court of Appeals and not from the district bench. But because it was a unit of the district court, they thought that the equity power that bankruptcy courts need to get the job done in handling the rights of creditors, debtors, and third parties, the equity power would then flow from the district court, who was an Article III court, to the bankruptcy court. A convoluted system, to say the least. But
It's interesting to me how many Southern folks were involved in all of this. I mean, Talmadge and Bell and Eisenstadt and you, the role that Georgia lawyers and Georgia people played in shaping our bankruptcy
well,
law.
that's right. And the president, Carter, happened to be president at that time, and these people like Stu Eisenstadt and Bob Lipschutz were very involved with the process. Lipschutz was a friend of Morris Macy, the dominant bankruptcy law firm in Atlanta for many years in the early 60s and 70s, and until the creation of the SBLI, which we haven't gotten to.
talk
yet.
We will.
We'll talk
But
about
just so
And,
happens Judge Bell's Attorney General of the United States.
Did
at
not
this
hurt
time.
either.
Did not.
But
The President will take his call.
matter of fact, it meant a great deal.
Yeah, absolutely.
Well, you have now been on the bench for a while.
A while.
You've seen
About
good
45
lawyers,
years.
bad lawyers. We have students out here and others who might be interested. What have you seen in your many years has impressed you about lawyers? And what things have you seen where you would say to a student, don't do that, don't ever do that? Can you give advice to our students out there about good lawyering in your court and lawyering that isn't
Judges
so
are
good?
different. You know, as I've alluded to earlier, I run a very strict formal courtroom. Expect lawyers to be prepared. Will not accept excuses for unprepared attorneys. But I do have some advice to give to young lawyers of things that they should probably avoid. For example, Your Honor, I couldn't be here last week because I had to be in another court. Now you can imagine how that might sit with the judge, and with me, not very well.
I had an important case to tend to.
Exactly, exactly. Or, Your Honor, you know, this matter is very complicated, indicating that perhaps the judge is too dumb to understand what's really going on, or else the lawyer doesn't know enough about it to explain it in proper form. Or, well, you know, Judge, I'm really not a bankruptcy lawyer.
Ouch.
You know, sitting in for somebody else perhaps, standing in, and wants a mulligan because he's not a bankruptcy lawyer. Well, you don't get mulligans in my court. If you come to court and you represent a client, I expect you to be prepared. And what else?
You're suggesting that you do not just dabble in bankruptcy law. If you're going to represent somebody in your court, they better understand.
Exactly. Or, Judge, I'm sorry, my secretary just didn't put this on my calendar. Don't ever say that to a judge. Never blame your staff. It's your responsibility, not hers. Or, Judge, I'll be brief. You know, he might think he's going to be brief because he doesn't know enough about his case, and the judge expects somebody to state his case in as long a time as the judge will allow the case to be presented. Or Judge, I'll get to that later. Can you imagine saying that to a judge who's just asked a question?
We try to train them better than that.
You
at
know,
Mercer.
instead of, obviously the judge has asked this lawyer a question, interrupting his presentation or her presentation. And he doesn't want to receive a comment that, you know, I'll get to that later. He needs to be good enough to interrupt his presentation and address what the court has brought to his attention.
Well, without naming names, like outstanding lawyers like Mort Levine, your friend out there, sitting there, the general level of competency of bankruptcy practitioners, have you seen an improvement? Have you seen a real difference between lawyers back in the late 70s and 80s and now?
Oh, considerable difference. Of course, we had some very good ones back then, but they were limited. There were very few. Most of the law firms in major cities, particularly in Atlanta, did not practice bankruptcy law. They farmed out, so to speak, matters that came to their attention in this field of law to a very few firms.
Why was that?
Well, I don't know why. It was something that they just didn't want to do, and they refrained from coming to the bankruptcy court. So the practice there was limited to a few. Led to some of the bigger firms to call it a bankruptcy ring, which is far from the truth. These are very competent people, but just didn't attract the attention of the big firms. I saw that as a problem.
But that's changed.
that's changed. I'll tell you what changed it in Atlanta was the creation of the Southeastern Bankruptcy Law Institute. And
And we're going to talk about that because I know back in the early 70s, what, 74 when you started?
well, we started with it in 1973, and I, at the outset, wanted it set here at Mercer University.
Before we get into that, all right, I want to go back for just a minute. We were talking about the advice you had for young lawyers, and I'm so glad, you know, that you did that.
Another one that I might mention
Well, I wanted to make sure we got them all.
is with all due respect, never say that to a judge. You know, with all due respect.
It's ambiguous how much respect
well,
is due.
Well, not that necessarily that, but they're obviously responding to a question asked by the judge, indicating that the lawyer thinks the judge is incorrect in what the statement he's just made. I mean, you don't say things like that. That phrase is unnecessary. You never say that anyway. And it's superfluous, and it makes the judge a little upset, to say the least.
Now, when lawyers have done things like this, especially young lawyers who don't know any better, who didn't go to Mercer, so they don't know any better, right?
Well, if they had, they would know better.
Absolutely, because Professor
Because they
Sapp,
would be taught that by Professor
And
Sapp
professionalism by
and
this.
professionalism by
That's
Professor
right,
Lonergan.
that's right.
but I know that over the years you have taken some of these lawyers aside to try to help them out. Can you talk a little bit about what you do?
I don't believe in embarrassing lawyers in the courtroom in front of their clients. I think that's unnecessary. Sometimes you can't avoid it. You might have to be a little strict in what you say to them. But if it's bad enough or serious enough, I ask them to come back to chambers. And in the privacy of my office, I talk to them about what I expect and what I expect them to handle their cases in the future. I just think that's more professional, and it avoids attorney-client problems.
I assume it tends to work.
I think it works. It's worked in my court.
Can we ask you just one more thing about the evolution of the bankruptcy system? Because, and I'm going to let Professor Sabbath really ask this question, but I understand there has been a relatively recent development that
Yes.
maybe bodes some ill.
This is just a further erosion of what I mentioned before.
All right, well, I'm going to let you
Well,
bankruptcy
the
lawyers
Stern
do
versus Marshall case, which the bankruptcy attorneys know about, my students will know about it when we talk about it. But again, it draws into question whether the bankruptcy court can hear certain types of matters, which they clearly are the best suited court to hear.
No question.
And the issue is, I mean, will we just need legislation? If it's not going to come, will there be litigation for years to come to try and sort out what this means?
I think unless we have legislation, yes, there will be years of litigation.
So who's going to push? Your generation, you pushed in the 70s. Are there people out there now?
The court is much more elevated now as a result of our efforts than it was then. There's no comparison. Right now we're in the red zone. Before we were on the 10-yard line, to use a football analogy. But the case of Stern against Marshall held that a bankruptcy judge without life tenure could not decide a case in which a debtor had filed a counterclaim against a creditor who had filed a proof of claim in the bankruptcy estate, in the bankruptcy case. And in spite of the fact that the counterclaim had been designated as a core proceeding under, I think, Section 157B2C
If he says so.
of the United States,
I
28
think that's
USC.
right.
And so that presents quite a problem. It was a close 5-4 decision in the Supreme Court, with the Chief Justice writing the majority opinion, saying that it was a very limited circumstance. You know, this should not disturb the overall jurisdiction of the court. But a lot of courts that have considered this matter have gone much further since then, Mike, and have caused further question as to whether or not the bankruptcy court as presently constituted can handle any number of things involving state law matters. And courts have split all over the country over this matter, many adopting local rules to further define the core, non-core situation, and saying that if the district court believes that this matter is beyond the jurisdiction of the bankruptcy court, that they can consider the findings, the bankruptcy court's decision as findings of fact and conclusions of law. But that is so inadequate, the public suffers as a result. You're talking about additional months of delay in resolving cases, and is further indication of the fact that the only way we're going to ever resolve this matter and get a tribunal in which all the rights of the public can be decided in that forum is through the enactment of an Article III legislation. And efforts are now being made again
That's good.
in that area to see that that comes about. Whether that'll be successful, I don't know. I've been through this so long and have experienced, even though some victories, some disappointing defeats in the process. If we can just get Congress' attention and focus on this, I don't think we're going to have the difficulties we've had in the past, because as I mentioned a while ago, the court has been elevated now to such a level till we don't have that animosity between the bankruptcy court and the general Article III bench that once existed.
But it's going to take legislation.
It'll take legislation, there's no question about that. Or else one of these days the Supreme Court is going to get this matter again, and they're going to may even go further eroding the jurisdiction of the bankruptcy court. So now you have major organizations in the country that can address this problem. We had very little help back then. But now you have the American Bankruptcy Institute, the SBLI, of course, the American Bar Association, I'm sure now would support it fully, the Commercial Law League of America, many, many others. And I think this is a propitious time to make an all-out effort to get the court we've needed for a long time.
Well, Judge, we've got a few other things to talk about. We're going to talk about SBLI that you've mentioned a couple of times. We obviously want to talk about your service to Mercer University. We've been going about another 40 minutes. Would you like to take one more break?
Yes,
and then
that'd
come
be
back
fine.
and we'll finish up? So we'll take about 5 minutes and then come back.
That'd be good.
And
Thank
we'll
you.
finish up. Judge, when we were talking about the evolution of the Bankruptcy Reform Act, you mentioned that in the midst of all that, you left the bench for a while. Do you want to talk a little bit about why you did that and then why you came back?
Well, after many years of trying to work out our problems with the judiciary and finally create this new system, a few of us became very frustrated with the progress. I mentioned that before. And this law firm in Atlanta was very interested in beginning a bankruptcy practice. So I went to Swift, Curry, McGee and Hires in Atlanta to begin that. Quite successful, I might say. They had no bankruptcy presence at that time, and we ended up with about 5 or 6 working directly with me in creating this bankruptcy practice. I was fortunate enough to attract a lot of cases countrywide because I'd been on the bench almost 12 years, knew people all over the country. And the practice of bankruptcy law in a big city is such that you're called out of town and on the road a lot and speaking here and speaking there and in this court and that court. And while I enjoyed practice to a certain extent and was successful at it, my boys were growing up at home without their father being present. I did not like that. I wanted to be there with them. My family means more to me than money, much more. And so when I had the opportunity, Ezra Cohen, who I had recommended to succeed me when I left the bench, the district judges appointed him, wanted to return to private practice. It just so happened in 1979. And he talked with me about it, and so that suited me perfectly. That furnished me an opportunity to come back to the bench, spend time at home with Ruth and the boys, watch them grow up. It's one of the best decisions I ever made, and I've never regretted it.
They were quite young.
Very young, very young. I think Walter was about 9 when I came back, and Taylor about 6. So I got to see them grow up in their formative years, and would take nothing for that. And so I've been on the bench a long time.
Yes, you have. Well, Judge, I want to switch gears here to another facet of your life that's been central to your achievements and your contributions, and that's Mercer University.
By all means.
This goes back to your time as an undergraduate and continues, obviously, today. Can you tell us a little bit about why you're so passionate about this university?
I always have been. When I came to Mercer in 1951, as an undergraduate student, it was just a great attraction for me. I've loved it ever since. It fit me like a glove, having been to the big university in Athens, and I participated in campus activities from the outset, and was extremely happy. We had as I've already alluded to, a great faculty, a student body that was, I think, very high class, a very good student body. And that expanded a little bit later on to when I graduated from Mercer, a continued interest in alumni affairs and the Board of Visitors of the law school. And I told you where we had a lot of our meetings down in Judge Bell's conference room in the old post office building in Atlanta. And that just through the years has interested me about as much as anything as I've ever done in my life, is my association with Mercer. And it's been one of the joys of my life.
Mm-hmm. Well, and you're wearing your Mercer orange tie. As
I always do.
As you always do.
I always do. I've got about 20.
Okay. Can you talk a little bit about, over that period of time, how the university has changed?
The university has gone from a small Baptist-oriented school in when I first came here in 1951 to, I think, one of the great private universities in the country now. What we had, as I said, the only professional school we had was the law school then. Now we have at least 11, maybe 12 different colleges and professional schools within the university. And we've been fortunate in having great leadership in the president's position of the university and of the law school, one of whom is sitting right here as dean for a couple of years, Mike Sabbath, yourself. We've had very distinguished professors here and able professors. Kirby Godsey was an outstanding president of the university for 27 years and did a great deal to improve Mercer in so many areas. Bill Underwood, whose his successor has been here for about 6 years, 7 years now, is a great visionary educator. I doubt that you would find a finer college president in the United States. I'm extremely impressed with him and enjoy working with him on the Board of Trustees to fulfill the vision he has for Mercer, which is that Mercer very shortly, and I'm talking about less than 5 to 10 years from now, will be the equal of any private university anywhere. Certainly in the class of Duke, Vanderbilt, Emory, Tulane here in the Southeast. And these students here are very fortunate in having the opportunity to go to Mercer at this particular time.
And you served as chairman of the Board of Trustees?
Chairman of the Board of Trustees recently for 2 years. I've been a member of the Board of Trustees for quite a while. And just I cannot tell you how much I love this university. We're experiencing a lot of different things happening right now. One of my loves and goals has been the resumption of football.
Well, I was going to ask you about that. We happen to have one of your football helmets.
That's right.
Here with us today.
I have a Mercer Shrine in my office, as you know.
Yes, you do.
And
can you tell us a little bit about the importance you see for the athletic program at Mercer, and in particular for the return of football? Because we hadn't played football in a long, long time.
Since 1941, I believe.
That's correct.
The first football game in this state was played between Mercer University and the University of Georgia in 1892. We lost that game. I won't mention the score. But the second game played in this state was between Mercer and Georgia Tech here in Macon. We won that game 12-6. And throughout the 50 years that we played, we have defeated schools like Florida Auburn, Georgia Tech, many others. Never beat the University of Georgia for some reason, although we came close many times. Now this resumption of football, and I stress the word resumption, there's not a beginning of football because it began here. We're going to play on a different level. We're going to stress the student-athlete approach, the non-scholarship approach. Young men who've enjoyed playing football in high school, continuing their love of the game in a college atmosphere, and what I might say will be in some of the finest facilities you'll find anywhere in the country that's currently under construction on the Mercer campus.
Which I'll say, because you won't, is I believe the Homer and Ruth Drake Fieldhouse.
That's right.
Thank you.
We are very pleased about that and glad to have had a part in resuming football here, because I think it's probably had more to do with the resurgence of the university recently than anything else. It's a great morale builder. Football is still king in the Southeast. Our response to the beginning football has already been unbelievable. And some 2,500 season tickets have already been sold and haven't even been released to the public yet for sale. The stadium is being increased to over 10,000. And we're in a football-only league. The schools within this league give scholarships in other sports, but not in football. So we're in pretty good company with schools like Davidson, Butler, Drake, Valparaiso, the University of San Diego, the University of Dayton. It's a national. Stetson also is entering the University of Jacksonville. So, and we're playing Carnegie Mellon from Philadelphia here this next year. So we're in good company. We are looking forward to it, and it'll be here before you know it.
Very good. I think we'd like to talk a little bit now about the SBLI. Is that?
Well, actually, you know, in addition to sports, you've always had an interest in academics. You've written a number of scholarly articles and books, and you've been an adjunct teacher at Georgia and at Emory, and in fact, you were my professor. I took bankruptcy from you back in '73.
You know, can you believe that? I recall that very well. And the highest, he won't say this either, but I'll tell you, the highest grade in the room was made by Professor Savage.
I'm not sure that that's true.
Out of about 90 students.
It was a packed room. And you know, you brought guests with you who I didn't know at the time who they were, but I believe Mort Levine, who's sitting out there, came. A fellow named Gus Small.
Who will be here today.
All-stars who, when I got older and practiced law, I realized that you really did surround yourself with a group of extraordinary people who helped to teach us.
I've really enjoyed the academic side of the law. I almost became a professor instead of a lawyer. Thought about it for a while. I came from an academic background, as I've explained to you, with my parents. And there's no reason why I should not have some love for academics. I enjoyed teaching at Emory at Georgia on an adjunct basis.
Right.
Handling court, you know, all of this while I was on the bench.
Right.
But teaching at Emory at 8 o'clock in the morning and getting to Emory in time for class from Noonan was a chore.
It was hard for me to get up and be there at 8 in the morning. And I lived right down the street. So
Now at Georgia, when Lindsey Cowan, did you know him?
Yes, I did.
Was the dean. He asked me to teach over there, and I arranged that around football weekends in Athens.
Yeah.
Much to the chagrin of the students, I had classes on Friday night and Saturday mornings, so you can imagine how they loved that. But I enjoyed that. And then later on at Georgia State, some as well.
Well, and you know, not just teaching students, but this SBLI, the Southeastern Bankruptcy Law Institute, continues to educate attorneys who practice in the area. And tell us a little bit how that came about and what you hope to achieve when you started this organization.
All right. I've already mentioned to you the limited nature of bankruptcy practice when I took the bench in Atlanta. Just a few lawyers, very good lawyers, but just a few, limited practice. I could not understand why the bigger firms were not interested, particularly since so much money was generated through bankruptcy practice, these big cases that we handled. And there were some big ones. So I developed this idea that it would be a wonderful thing to find a way to involve the bigger firms as well as the smaller firms in bankruptcy law. Originally, the thought had been to come through Mercer or through Emory. Ray Patterson, who was my classmate at Mercer, happened to be the dean at Emory at the time. He later on went to the University of Georgia as a professor. I thought he was going to be receptive, but something happened there, it didn't work out, and it didn't work out here, although Ed Wilson wanted it. He was the dean at the time, with Dr. Harris. You might remember Dr.
I
Harris.
remember Dr. Harris.
And so several of us in Atlanta got together and decided that we'd just form our own corporation. So we did, had it incorporated in Fulton County, and called it the Southeastern Bankruptcy Law Institute, which was formed to educate members of the bar in bankruptcy matters. And in doing so, we brought professors and the judges from all over the country to help us in that effort. I mean, some of the names I've already mentioned in helping to eventually achieve the passage of the Bankruptcy Reform Act of 1978. Professors like Frank Kennedy, Vern Countryman, judges like Conrad Sear, Arthur Moeller, Joe Lee, many, many others. So we had an all-star faculty. I appointed all of the members of the board of directors of the Institute to start with. There were about 15. Mostly from larger firms, some from smaller firms. We tried to achieve a balance. One of the rules that we had at the outset, and we still do, is that as good a lawyers as we have in Atlanta, and we do have found a bankruptcy bench in the country, largely because of the SBLI, in my opinion. None of our lawyers or judges were never able to serve as a member of the faculty. That has avoided all kinds of jealousies through the years. All participants had to come from outside, and we had plenty of those available, so it was not necessary to have any local involvement. And I cannot tell you what it's meant. The SBLI has contributed well over $1 million. I'd say close to $1.5 million to law schools in Georgia and the Southeast since its inception, and continues to do so. And while we don't have the attendance we once had in the early 80s, we had some 1,200 to 1,400 lawyers and judges from all over the country here for a 2.5-day period in the SBLI. Now it's about 500 or 600, still the largest and most prestigious bankruptcy seminar in the United States. And these young people here who are interested in bankruptcy law, I would suggest that they always make it a point to attend the SBLI in Atlanta, which is in the spring of every year.
Now, I understand that one of the things the SBLI has done, particularly for Mercer, is to help create the Drake Chair.
Guess who holds that chair?
Well, let's see if we can.
I am honored to, the SBLI to honor this gentleman.
There he is, Your Honor, when
right.
he became at first the Drake Professor, and then it's now a chair. We have the Drake Chair right here.
But we should point out that in addition to the generosity towards Mercer, you've helped all the schools. I mean, a number of schools in the Southeast. I think in addition to the chair here, we have a library collection that is largely due to the SBLI.
Which is right here in our own law school.
Right in our, now tell me the future. You know, what do you see SBLI doing in the years ahead?
Well, continuing to educate the members of the bankruptcy community. I think that's an extremely important thing to do, and as I said, we still have the most prestigious and well-attended bankruptcy seminar in the United States. They come from all over the country. And what I envision also, and there's some of our people here today, is to help educate Congress about the necessity of alleviating the problems we face with this truncated and bifurcated bankruptcy system that we have now, and create an Article III court at last. And the SBLI is in the education process, and Congress can use some educating in that regard.
Judge, we've talked a lot about law and bankruptcy and Mercer, and I want to turn our attention here as we near the end of our time together back to you and your personal history. I'll tell you, in teaching the current generation of law students, I'll tell you one of the biggest concerns they have, and maybe it's every generation, but certainly this generation, is how are they going to balance their professional demands with a private life and with family and with community. Somehow you have done that. I mean, you have had a full career and you have had a wonderful family life and you've devoted yourself to your community and your church. How do you do it?
I've done the best I can, and I had some help along the way from somebody named Ruth. And you cannot imagine the help that has been to me and my sons. But insofar as these lawyers are concerned, these students, there's a little book that was written by Arthur Harris called Letters to a Young Lawyer that I would recommend that each of you get a copy of and read. I don't know of any better advice that you can have than this little book. It's letters that a lawyer wrote to his son who's just graduated from law school. It was originally published in around 1912. I gave it to Taylor when he graduated, and it still is vibrant and applicable today as it was then. And so that's one of the suggestions I would have. And of course, there's no substitute for hard work, commitment, and always remember that rewards come to those who are willing to pay the price. There's always a price in everything you undertake, and you have to always remember, and you have to decide for yourself whether or not the price is worth the prize, worth the goal. Dedication, commitment, and perseverance are attributes that I think you should always keep foremost in your mind. And tolerance of others' beliefs, a willingness to get along with your fellow lawyers, and respect for the profession, and things of that kind.
Well, as you talk about prizes in life, Judge, I want to direct your attention to the last picture. Who are those people?
I tell you, those are six.
One of them's here today, right?
One of Harrison is here. Those are six of my favorite people, my grandchildren. And we had that picture made when the stadium groundbreaking took place. We walked up to the University Center together and took that picture around the Bear.
Well,
So we're very proud of that.
looks like you're sending them in the right direction, a whole nother generation of bears.
That's right. I hope they all go to Mercer.
Very good. Well, Judge, at this point, what I'd like to do is give the students a chance, or really anybody else in the audience, a chance to ask you any questions before
If I can answer them,
before
I'll be happy to.
we wrap up. So, do we have any oh, there we go.
First of all, I'd like to say thank you for letting us sit in and listen to a little bit of your history. It's been a great privilege. I was wondering if you had any advice for the students that want to get into the bankruptcy practice, besides getting involved with the SBLI, besides taking Professor Sabbath's class. What can we do to kind of make ourselves more competitive when entering the job market?
Well, good grades is a good start. And I think one of the best ways to enter bankruptcy practice is what I believe, didn't you intern this last year?
Yes, sir.
With Judge Bonifel in Atlanta? That's a great start. I don't know of any better way to get to be a successful bankruptcy practitioner than to secure a clerkship with one of the bankruptcy judges upon graduation. That enables you to see it up close and to see what the judges expect. And then you can meet all kinds of lawyers in the process, decide who you may want to practice with. And so that's one thing that I would suggest that you pursue. And all these other things, when you get out in practice, don't be too eager to leave what you're doing. I mean, don't change jobs too many times. I mean, that does not look good on a resume if you're ultimately going to seek employment elsewhere. Just sit down and think about it, be patient, and then you will make the right decision, I'm sure.
Judge, how about working for a trustee in a trustee's office? Is that good preparation?
Trustee, of course it is.
That would be another option.
It would be another option for Chapter 7 trustee, perhaps, or Chapter 13 trustee. I don't think it's as valuable as a clerkship, but they are difficult to obtain, and usually only the better students are selected by judges.
You know, we've talked about the evolution of bankruptcy proceedings, and part of that, I think, is the evolution of technology, especially the use of internet. How has that changed bankruptcy law, and how do you see that continuing in the future, especially with the
I think you may be talking to the wrong person about about the internet and these new technical developments. I know all of that's in my courtroom. I don't use them very much. I'm of the old-fashioned kind judge, and to believe in direct contact with the bar. I want to see your face. I don't want to be looking at some computer and thinking about electronic devices. But you can ask Professor Sabbath or Professor Lonergan, any of these here, and they can perhaps help. But the bankruptcy court is like the district court or superior courts with all of this technology. And a lot of judges use those and are very adept at doing so, but I'm not one of them. I know they exist, but I use them to a limited extent, perhaps. I wish I could help more in that regard.
No, thank you.
Anything else?
Other questions?
Well, thank you for coming. Appreciate your attendance.
All right. Thank you, Judge.
you.
Thank you, Judge.
Thank you very much.